a retroactive effect only insofar as they favor the person guilty of a felony who is not habitual. So Articles 21 to 22 speaks about uh, only uh, characteristic of criminal law, which is prospectivity. Penal law shall only have prospective application as a general rule, and it can only given a retroactive application if it is favorable to the accused, unless the exception uh, would set in. Okay, let's go to Article 25. Penalties which may be imposed. The penalties which may be imposed according to this code in their following their different classes are those included in the following. So yeah, we have the principal penalties. Okay, let me annotate this one. So we have the principal penalties as well as the accessory penalties. So let's discuss first principal penalties, capital and afflictive. Capital and afflictive would fall under uh, grave felonies. Okay, when you talk about capital punishment, it speaks about death, afflictive, RP, reclusion perpetua, reclusion temporal, perpetual or temporary special disqualification, absolute disqualification, perpetual or temporary absolute disqualification, and prisión mayor. Okay, sige. Let me just clear this. When you talk about correctional penalties would be um, grave. This is not a grave felony, but this is a less grave felony. Let me check. Clear. Yeah. So correctional felonies will fall into less grave. Prisión correccional, arresto mayor, suspension, and destierro. And common to light penalties will fall into light felony, arresto menor, and public censure. And penalties common to all of them will be fine and bond to keep this. So we have now the accessory penalties. Yan. Itong perpetual, temporary, absolute disqualification as well special disqualification, they can be principal penalties as well as accessory penalties. So we have perpetual or temporary, absolute or special disqualifications, suspension, civil interdiction, indemnification, forfeiture or confiscation of instruments and proceeds of the offense, and payment of cost. Now take note na sa accessory penalties, meron siyang suspension from public office, the right to vote and be voted, profession or calling would be deemed as accessory penalties. Okay, let's go to fine. Fine. It could be, let me annotate, it could be afflictive, correctional, and light. Afflictive, correctional, and light. So notice that the amount is now 1.2 million. If it exceeds 1.2 million, that will be afflictive. If it is 40,000, between 40,000 pesos to 1.2 million, that will be correctional. And light if it is less than 40,000. So pag light, less than 40,000. Pag afflictive, more than 1.2 million. So correctional in between is exactly 40,000 pesos and up to 1.2 million pesos. Okay, next. So let's go to Article 27, true or false. The penalty of reclusion perpetua, you know the duration is 20 years, 1 day to 40 years, diba? So there's a question in the 2009 bar. Question is, life imprisonment is a penalty more favorable to the convict than reclusion perpetua. So it's life imprisonment is more favorable uh, to the convict than reclusion perpetua. Suggested answer, false, because life imprisonment is actually unfavorable to the convict, because you may know that the penalty of reclusion perpetua has a duration of 20 years, 1 day to until 40 years. And he can be eligible for pardon. But life imprisonment, on the other hand, is beyond 40 years and it has no fixed duration. Okay, so I would assume all of you have memorized already the durations of penalties. Okay, so may tanong sa reclusion perpetua, may tanong din sa prison mayor. Prison mayor carries the penalty of 6 years, 1 day to 12 years. Okay. So let's go to Article 29. It talks about detention prisoners. So, kailan ba isang tao nagiging detention prisoner? He's not yet a convicted felon. But a person who has a criminal case is unable to post a bail, or if he's charged with an unbailable offense, non-bailable offense, then he can be a detention prisoner. Now, the time for during which he's under detention may be credited when he's actually convicted later on. So kung 2 years siya na-detain and then he was convicted, that 2 years may be credited depending on whether he agreed in writing to abide by the same disciplinary rules as that of the convict. So if he agrees in writing, it's the whole time will be credited. If he does not abide by the rules, then it's four-fifth credited. Now, uh, if uh, if he is under prison for more than the possible maximum duration of imprisonment that he was charged, then he can be released already. So halimbawa ang penalty is 3 years, but he is already in prison for more than 3 years, say 5 years. So he can be released already, okay, without prejudice to the continuation of his criminal case or trial. So, syempre, pagka hindi inalaw ng court, then you can avail of other remedies like habeas corpus because of this provision. Pardon. Pardon. May tanong sa 2015 at 4 bar exams. Okay, a pardon shall not work the restoration of the right to hold office. or the right of suffrage unless such rights can uh, be expressly restored by the terms of the pardon. Of course, or also a pardon shall in no case exempt the culprit from the payment of the civil liability imposed upon him by the sentence. So, importante rito, a pardon. Now, pardon can be extended by uh, the president, and pardon can be extended by the offended party. So, sa offended party, yung pardon can only extinguish criminal liability if it falls under Article 344. Yung private offended offense like concubinage, adultery, seduction, abduction, uh, acts of lasciviousness. But other than that, it will not uh, extinguish criminal liability. But a pardon extended by the president shall extinguish criminal liability. Now, what else? Yung pardon extended by the offended party may extend up to civil indemnity, but a pardon extended by the president shall not cover civil indemnity. Okay, pardon extended by the offended party, dapat yan should be before the criminal prosecution, extended before the uh, start of the criminal prosecution, while the pardon extended by the president, okay, should be after conviction. So dapat ito yung the right to hold office niya sa right of suffrage should be expressly restored by the terms of the pardon. Why? Kasi ganito yun. Yung pardon extended by the president should only extinguish criminal liability on the principal penalty. Okay? Mag-extinguish yung principal penalty ng imprisonment. But it shall not affect yung accessory penalty. And the right to hold office or the right of suffrage is an accessory penalty. So hindi mag-extend din unless expressly restored by the terms of the pardon. So let's read on the 2015 bar examination. So Senator Adamos was convicted of plunder about 1 year after beginning to serve his sentence. The President of the Philippines granted him absolute pardon. The signed pardon states, "In view hereof and in pursuance of the authority vested upon me by the Constitution, I hereby grant absolute pardon unto Adamos, who was convicted of plunder in criminal case so and so, and upon whom the penalty of reclusion perpetua was imposed." Now, si Senator Adamos would come to you for advice and wants to know if he could run for senator in the next election. So what advice would you give Adamos? Explain. Ano ba yan? Express ba yon? Doon ba, naka-express ba doon sa pardon extended by the President? Yung sinabi ng President ng in view hereof and in pursuance the authority upon me, I hereby grant absolute pardon unto Adamos. And that's it. Answer. If I were the counsel of Senator Adamos, I will give him the advice that he cannot run in this senatorial race. So while pardon looks forward and relieves the offender from the consequences of an offense, okay, for which he has been convicted, however, under Article 36, a pardon shall not work the restoration of the right to hold public office unless such right be expressly restored by the terms of the pardon. So this is your legal basis. This is your, di ba, yung ano natin, yung format natin, your reply, or how do you respond to the question, R, L, and then another legal basis, which is under Article 41, penalty of reclusion perpetual shall carry with it perpetual absolute disqualification. which the offender shall suffer even though pardoned as to the principal penalty, unless the same shall have been expressly remitted in the terms of the pardon. So then now we have the application. So in this case, since the terms of the pardon extended by the President have not expressly restored Senator Adamo's right to hold public office, kasi ano naman lang, in general terms lang, and or limited the accessory penalty of perpetual absolute disqualification, then he cannot run in the senatorial race. Pecuniary liabilities, order of payment. You've got to memorize this. In case the property of the offender shall not be sufficient for the payment of all his pecuniary liabilities, the same shall be met, okay, in the following order. So, reparation, indemnification, fine, and cost. RIFC. Reparation of the damage caused, indemnification of the consequential damages, fine, and cost of the proceedings. Now, our subsidiary penalty. Insofar as subsidiary penalty is concerned, remember that this is only applicable to non-payment of fine. It does not apply to non-payment of civil indemnity or damages. And ang pag di siya nakabayad ng fine, then he can be required to go up to subsidiary imprisonment of 1 day equivalent to the highest minimum wage rate. 1 day equivalent to the highest minimum wage rates. So titingnan nyo, maraming mga trick dito sa bar exam. Kung hindi naman non-payment of fine, wag nyo i-apply. At dapat it should be express. Anong express? Expressly stated that in case he failed to pay the fine, he will be required to undergo subsidiary imprisonment 1 day equivalent to the highest minimum wage rate. It should be indicated in the decision. Hindi lang just because nakalagay doon, required to pay the fine, automatically he can be required to undergo subsidiary imprisonment if he fails to pay the fine. No, dapat ito express. Hahanapin nyo sa decision ito. Otherwise, mamamali kayo. Okay. Ano pa mga conditions aside from being expressed? Titingnan niyo ang penalty. If the penalty is prison correctional, fine, or arresto, PAF, okay? PAF, prison correctional, arresto, or fine, okay? Ang kanyang subsidiary imprisonment should not exceed 1/3 of his sentence, and in no case shall it exceed 1 year. So ang kanyang subsidiary imprisonment shall not exceed 1/3 of his sentence. In no case shall it be exceed 1 year. Okay, pagka fine lang siya, if the principal penalty imposed is purely fine, titingnan nyo ngayon kung it shall not, if grave or less grave. If the culprit had been prosecuted for grave or less grave. Okay? Or light felony. If it kung grave or less grave felony, di ba, the subsidiary imprisonment shall not exceed 6 months. If light only, shall not exceed 15 days. So ito ay kung purely fine lang ang kanyang principal penalty. Determine kung grave or less grave, in which case, kung grave or less grave, it shall not exceed 6 months. If it is a light felony, then it should not exceed 15 days. Now, if the principal penalty is higher than prison correctional, then no subsidiary imprisonment. Tandaan nyo, kung mahigit sa prison correctional ang penalty, wala ng subsidiary imprisonment. So kung ang penalty is reclusion per temporal, which is higher than prison correctional, or prison mayor, both higher than prison correctional, no subsidiary imprisonment. So titingnan nyo kasi baka pamaya itong penalty, principal penalties, i-determine nyo pa, hindi na express provision eh. Kahit ang nakalagay doon, may fine siya. Okay, let's go to another point. Ito. Let's discuss the bar examination last year lang. Mr. Q was found guilty beyond reasonable doubt of the crime of serious physical injuries and accordingly was sentenced to suffer the penalty of imprisonment for an indeterminate period of 6 months of arresto mayor minimum to 4 years, 2 months, and 1 day of prison correctional. So wala tayong problema sa sa penalty because it did not exceed prison correctional. Now nakalagay dito sa facts. He was also ordered to pay the victim actual damages in the amount of 50,000 pesos with subsidiary imprisonment in case of insolvency. Question, was the imposition of subsidiary imprisonment proper or not? Explain. Material ito sa sentence ng he was also ordered to pay the victim actual damages. Answer. No, the imposition of subsidiary imprisonment is not proper. Why? Because Article 39 is explicit in that it provides that if the convict has no property with which to meet the fine, he shall be subject to subsidiary penalty of rate of 1 day for each amount equivalent to the highest minimum wage rate. Okay? Again, nakalagay dito is to meet yung fine. Okay? To meet the fine. In this case, it's not fine, di ba? So, wait. Dito, in this case, the Mr. Q was ordered to pay the victim actual damages only and not fine. Hence, subsidiary imprisonment cannot be imposed. As I emphasized a while ago, it's not applicable if there is non-payment of damages because subsidiary imprisonment is only applicable to fine. Okay? Yan. So, pero tatandaan nyo, Sa subsidiary imprisonment, ganito. Take illustration number 1. So, dapat fine lang. Pag ang in-impose is, nakalagay doon, is to pay civil indemnity or liability, and there is non-payment thereof, okay, not applicable kasi fine lang. Okay? Number 2, um, nakalagay dun sa facts of the case, halimbawa, example, the penalty is prison correctional, okay, and to pay fine, period. Bawa ang sa decision lang, prison correctional and to pay a fine in the amount so if so. Tapos period na. Okay, can he be required to undergo subsidiary imprisonment? No, still not applicable. As I mentioned a while ago, it should be, requirement is that it should be express. Ano ibig sabihin ng express? Dapat ganito. Number 1, so yung penalty, halimbawa, penalty indicated. Number 2 is to pay fine. And number 3 is that, ito, in case, okay, in case the convict fails to pay the fine, then can be required to undergo a subsidiary imprisonment of 1 day, equivalent to the highest minimum wage rate. Period. So dapat ito yon, hahanapin nyo to. In case he fails to pay the fine, then he can be required to undergo subsidiary imprisonment of 1 day, equivalent to the highest minimum wage rate. So notwithstanding that there is an indication of the penalty as well as requirement of fine, still, okay, not be required to undergo subsidiary imprisonment pag wala nitong number 3. So trick in the bar yan. Remember that. Favorite bar question. Ito. And number 3, kung if the penalty exceeds prison correctional. Okay, no subsidiary imprisonment is required. So those are the tricks in the bar examinations. Okay, let's proceed. Let me just stop this one. So sana tayo. That okay na yan. Let's go to 46, penalty to be imposed upon principals in general. The penalty prescribed by law for the commission of a felony shall be imposed upon the principal in the commission of such felony. Whenever the law prescribes a penalty for a felony in general terms, it shall be understood as an applicable to consummated felony. In other words, yung penalty prescribed by law for the commission of a crime or a felony is imposed upon whom? The principal. In what stage? In a consummated felony. Upon the principals in the consummated stage. Understood na yon. The penalty prescribed by law for the commission of a felony. Let's go to a complex crime. naman, daming bar exams dyan, no? Okay. So let's discuss this one. I will gonna be using the whiteboard. Article 48 speaks about complex crimes. Two kinds. You have number one, compound complex crime. And you can gauge this sa first sentence. Nakalagay, when a single act constitutes, okay, two or more grave or less grave felonies. So that's a compound complex crime. When your single act constitutes or is equivalent to two or more grave or less grave felonies. Now, so it's not correct to say therefore that um, two crimes are committed by reason of single act, that it constitutes automatically a compound complex crime. No. Dapat yung dalawang crimes that are produced should be classified as grave or less grave felonies, not light felony. Pagka light felonies ang na-produce ng single act, it is not a complex crime. Kanina sinabi natin grave felonies, covered niya yung capital, saka afflicted, less grave correctional penalties. So therefore, prison correctional, arresto mayor, suspension justero. Pag ang penalty is arresto menor, hindi siya grave or less grave, light siya. What do you mean two or more grave or less grave? So dapat yung single act na yun would produce, number one, it can cover two grave felonies. It may also cover two less grave felonies. Number three, it may cover one grave felony and one less grave felonies. Again, not lights. Not when the penalty is arresto menor. So, let's illustrate this one. A intended to kill B through a hand grenade, killing B. C, a bystander, only suffered slight physical injury where the penalty is arresto menor. Question, is there a complex crime? The answer is no. There is no complex crime. While there is one person who died, which could produce a grave felony, but the other crime is only a light felony, which is punishable by arresto menor, 1 day to 30 days. The injury sustained by the victim is only slight physical injury, punishable by arresto menor, which is a light felony. So hindi siya complex crime. Next, A, through a hand grenade killing, intending to kill B through a hand grenade against B. Killing B. Killing his companion C as well. And a bystander by the name of D suffered slight physical injury. Tanong, meron bang complex crime? May complex crime ba? B could died, so one grave. C died, another grave felonies, but they only suffered slight physical injury. and the penalty is only a light felony. So victims B, C, and D. B and C died. B suffered slight physical injury. Is there a complex crime? The answer is yes. Kasi ang sinabi natin, two or more grave or less grave felonies. The death of B and the death of C would satisfy these requirements. It is immaterial if there's another person, a third person, who suffered injury or not even suffered an injury, because these two alone would already give rise to a compound complex crime. Kahit nga hindi siya na-injured kahit na walang D na na-injured Pag ang B and C namatay, compound complex crime na yun. Number 2, the second part of Article 48, which is complex crime proper. Diba? When a single act produces two or more grave or less grave felonies, or when an offense is a necessary means to commit another. When an offense is a necessary means to commit another. So another offense. So the question is, what is the meaning of necessary means? Is it equivalent to indispensable means? The same ba sila? No, it's not. They are not the same or equivalent. It is only a necessary means, not an indispensable means. Meaning to say that that offense is not an indispensable means to commit another one. Kasi when you say indispensable means, it is only an element of the crime. It is only inherent. What the complex crime includes is only a necessary means. Kasi pag indispensable means, hindi na siya complex crime. It is the crime itself. Okay? Now, halimbawa, is there a complex crime of estafa through, number 1, falsification of a public document? Is there also an estafa through falsification of a private document? Himayin natin siya. What is the difference between falsification of a public from that of a private document? Pag public document, all you have to prove is what? The act of falsification. And secondly is that it involves a public document. 2 elements lang yan pag public document. Pag private document, 3. The act of falsifying. Second is that it is a private document. And third is that it is there is damage. Damage is an essential element of a private document. So comparing the two, which of the two is easier to prove? Falsification of a public document. Why? Because damage is not an element. 2 elements only are needed to be proven by the prosecution. Because it involves the integrity and sanctity of a public document. So private document, hindi big sabihin na it involves the act of falsifying in a private document, a falsification of a private document na. No, damage should be proven as well. Now, you know that in estafa, there are two kinds. Estafa through abuse of confidence and estafa through deceit. But what is the common element between the two? The common element is that in estafa, either abuse of confidence or deceit, is that there is damage. So estafa, damage is indispensable element. Private document, falsification of a private document, damage is also an ingredient or an element of the crime. Okay, so let's go back again to the question. Is there an estafa through falsification of a public document? Is there an estafa through falsification of a private document? Meron bang private document na complex crime with estafa? No. Why? Because damage is an element of the crime of estafa, an essential, indispensable means to commit the crime. In a private document, falsification as damage is as well an ingredient or an element of the crime. So there is no estafa through falsification of a private document. But there could there be an estafa through falsification of a public document? Yes, because in a public document, falsification, damage is not to be proven because it's not an element of the crime. So let's summarize sa complex crime. Sa complex crime, not applicable if nakalagay if the other one is a light felony, if the other crime produced is a light felony. Okay, if it is not an indispensable means. Okay, third, meron pang tatlo. If it is not complex crime is not applicable if the other crime is a special penal law or okay, kasi ang complex crime is only applicable to both offenses punishable under the revised penal code. So there can be no murder with illegal possession of firearms. So there can be no bribery, a complex crime of bribery with the Anti-Graft and Corrupt Practices Act. No, because the other crime is an SPL. So light felony, not an indispensable means. If the other crime is not RPC or if it is an SPL. Number 4, if it is used as a means to conceal a crime. Still not indispensable yon. Bawa si A killed B in his house. While B was sleeping, A killed B. Now, to conceal the crime, what A did is to burn the house of B while B was inside. Is there a complex crime? No, because the purpose is only to conceal another crime. To constitute as a complex crime, it should be a necessary means to commit another crime, not when it is to conceal a crime. Okay? Malinaw siya. Now, what is the penalty? Penalty of a complex crime, it's still under 48. And the penalty is for the most, sabi ng batas, most serious crime the same to be imposed in its maximum period. Pagka-complex crime under Article 48 is for the most serious crime and to be imposed in its maximum period. A special complex crime does not have this penalty because the penalty is provided under that specific provision of the revised penal code. Halimbawa, si A A killed by chairman. Bakit? Pinakulong ni chairman si A because of his unruly behavior. So tinandaan ni B yun, ni A yun. So there was a grudge. So he planned on killing B. And true enough, while B was had no inkling that his life is in danger, A killed B. So in this crime, okay, he was charged with direct assault. Why? Because B being a barangay chairman. So a complex crime of direct assault with murder because B died. Now, direct assault with murder, between the two, which one is the most serious crime? Direct assault or murder? Murder. So the penalty for murder will be imposed in a complex crime. And you have to impose it in its maximum period. Sir, query, question, paano kung merong ordinary mitigating? Like he voluntarily surrendered to a person in authority. So can it offset so that it should not be imposed to its maximum period? No. It is always on its maximum period. Remember that in aggravating circumstances, meron tayong generic aggravating, we have specific, inherent, we have special aggravating. And the special aggravating is this one, complex crime. It cannot be offset by any ordinary mitigating. So not offset by ordinary mitigating. So kahit meron siyang plea of guilt, voluntary surrender, passion obfuscation, so not applicable. Paano sir kung merong privilege mitigating? Will it be applicable? Yes. Apply mo ang privilege mitigating. If for example, the offender is 17 years of age, acting with discernment, baba ka ng 1 degree lower, but still impose in its maximum period. So ordinary mitigating, not considered. Privilege mitigating is appreciated, but still impose it in its maximum period. Okay? So let's have a break. And then we'll be discussing part 2 of the penalties. Carla, pwede na ngayon, no? I-off. So we'll have a